May it please the court, Your Honor, opposing counsel, members of the jury. This case is about not one, not two, but three missed opportunities. My name is Nathan Nelson, and I represent the plaintiff, Pat and Tammy Scruggs, parents of the child, Sam Scruggs. Sam Scruggs was a young boy, happy, loving, and energetic. He wanted to be a baseball player one day, maybe pitch in the World Series. On July 11, 2013, he was enjoying his day with a family at Bayview State Park. The sun was out, and it was a Sunday. Bayview State Park has a highway that runs directly through the center of that park. And around 1 p.m., Sam Scruggs approached the side of that highway, took 2 steps, looked both ways, and began to cross. A truck 200 feet away saw this, slammed on its brakes, leaving screeching tires and smoke in its wake. He was able to avoid hitting that child. Now, the defendant was driving in the opposite lane. She was on her phone. Having just had a few margaritas, she didn't hit the brakes when she saw the child. She didn't hit the brakes when he took 2 steps. And she didn't hit the brakes when she heard the screeching of the tires. The defendant hit Sam Scruggs. Bouncing off the hood, smashing into the windshield, Sam Scruggs flew 30 feet away, slamming into the pavement. Now, Pat and Tammy Scruggs, they have to live every day watching their child struggle with the easiest of tasks. As the plaintiff, we hold the burden. We accept that burden. We must prove that the defendant was negligent on that day. But it's important to know that our burden isn't beyond a reasonable doubt, like you may have heard. This is not a criminal case, it's a civil, meaning that we must prove that the defendant was negligent by what's called a preponderance of the evidence. It means simply that the defendant was more likely than not negligent. And if we're able to tip the scales ever so slightly in our favor, we have proved our case. And I'm confident we will, because we're going to call before you 2 witnesses. The first, the truck driver, Alex Flyberg, he's going to take the stand here, and he's going to tell you what he saw. He's going to tell you that he saw the warning signs, the child on the road, the 2 steps, that he saw the child look both ways. And that's why he was able to stop on that day. You also hear from an expert, Dale Newcomb. Now, he's an expert in accident reconstruction. He's the only accident reconstructionist you'll hear from today. With over 30 years of experience and having taken numerous advanced courses in accident reconstruction, he'll tell you the test that he did and the calculations that he came up with. And finally, about his conclusion, that if the defendant wasn't distracted, wasn't on his phone, and hadn't had any drinks, she might have missed the child. Now, throughout the trial, I want you to be paying attention and looking for those 3 opportunities. The child stepped near the road, took 2 steps, and then the screeching of the tires. And at the end of the trial, my co-counsel, Luis Raballo, will come before you and review all of that testimony you have heard and go over with you all the evidence you have seen. And I'm confident that at that time, you'll find the defendant negligent, because the defendant missed each and every opportunity. Thank you.
For defense, you may proceed.
Thank you, Your Honor. Members of the jury, opposing counsel, may it please the court? A fraction of a second, an instant, a flash, a moment in time. Members of the jury, that's all we're talking about here today. A moment in time, a fraction of a second. And the question for you is, could Mr. Snyder have done everything that the plaintiffs say he should have done in that moment, in that fraction of a second? But there are other questions that need to be asked today. Other questions that you will see will be asked and answered for you to decide who's at fault. Good morning, ladies and gentlemen of the jury. My name is Alex Romano, and with my co-counsel, Mr. Sergio Lozano, we have the honor of representing the defendant in this case, Lynn Snyder. Let's start by talking about some of the people you're going to hear from today. People that were there that day. People that saw what happened. People that heard what happened. And people that are going to tell you what happened. You're going to hear from Lynn Snyder, the defendant in this case. He's going to tell you that weekend, July 11th, he was in Nita City visiting his friend Devindra. He's going to tell you that on July 11th, that morning, him and Devindra decided to treat themselves to brunch, a large seafood brunch. After brunch, they headed out. They headed out around 12:30, leaving plenty of time to make their flight at 3:30. Lynn Snyder is driving down Suncoast Highway. It's a beautiful sunny day. He's sitting behind the wheel with his passenger Devindra sitting right next to him. As they're driving down Suncoast Highway, a 2-lane road that goes through Bayview State Park, everything seems normal. Mr. Snyder is going with the flow of traffic, going far below the speed limit. Everything was normal. Until Mr. Snyder noticed a boy on the other side of the road up ahead, and thought to himself that the boy must be waiting to be picked up. But then, everything changed in that moment, in that fraction of a second. Lynn sees a little boy to his left running in front of his car, running into his lane, and he slams on his brakes as hard as he can. The car comes skidding to a stop. But it couldn't stop in time. And that, ladies and gentlemen, is why we're here today. Today, you will also have the opportunity to hear Trooper Sandy Fielder, not only a state trooper, but the lead investigator of the accident that occurred. And he was there that day. He comes before you as an expert, and with his expertise and training, he will tell you how and why he concluded the accident was unavoidable. You will also hear 2 other depositions, 2 other people. You will get to hear their words because they have submitted their sworn statements. You will get to hear what they saw, what they heard, and what they did that day, in their own words. Specifically, you'll hear from Jan Moriarty and Robin Scruggs. Jan Moriarty was a shuttle bus driver directly behind Lynn Snyder and had the unique perspective of sitting in her driver's seat in the elevated bus. Jan Moriarty could see what happened, could see the moments leading up to the accident and the accident itself.
Take your glasses off. Okay, continue.
Thank you, Your Honor. You will also have an opportunity to hear from Robin Scruggs. You'll get to hear the words of her sworn statement. Robin Scruggs is a minor that was entrusted by his parents to care for 6-year-old Sammy. a minor that was entrusted to go all the way across to the other side of Bayview State Park, where he was to play ball. There at the fields, he met with his friend Jessica. And it's there that Sam was left alone.
Objection, argumentative.
Overruled, I believe she's just stating what she believes the evidence will show.
Yes, sir.
Thank you, Your Honor. While Robin was playing ball, Sam was left alone. Soon after that, the accident occurred. Members of the jury, today you may hear about cell phones and drinks and math equations, but the evidence tells a different story. A much simpler story, a story about a moment in time. Because that's what this case is about, a moment in time. You'll also hear about decisions. Decisions made by the plaintiff, Sam Scruggs' parents. Decisions like where Sam should go, who Sam should go with, and whether Sam should have been left alone. The evidence will show that the answer is no. Plaintiffs have made a claim here, a claim of negligence, and with that claim comes a burden of proving every single element by the preponderance of the evidence. They have to prove every single element. First, plaintiffs must show that there was a duty. We understand that when anyone gets behind the wheel of a car, they have a duty to exercise reasonable care. This element is not at issue. Second, plaintiffs must prove to you that there was a breach of this duty, that Mr. Snyder did something that he shouldn't have done. The evidence will not be able to be proven. The evidence will not support this element. 3, plaintiffs have the burden of proving to you that Mr. Snyder was the proximate cause of this accident. And the evidence will show that the proximate cause of this accident was not Mr. Snyder. 4th, injury. Plaintiffs have the burden of showing that there is an injury, but not just that there was an injury, that Mr. Snyder's actions caused this injury. Members of the jury, this burden to prove every single element will not be able to be satisfied today. At the end of this trial, my co-counsel, Mr. Lozano, will step in my place. He'll go over all of the facts of the case and the law in this case. And he will make it clear to you that there is only one just verdict. And that one just verdict is to find no liability for Mr. Snyder. Thank you. Thank you, Your Honor.
Thank you, counsel.
Members of the jury, this case is about missed opportunities. And when I say missed opportunities, I'm not talking about one. I'm not talking about two. I'm talking about 3 opportunities the defendant had on July 11th, 2013 that he missed. He missed those opportunities and drove into a child, a 6-year-old child crossing the road. And every one of those opportunities were missed because the defendant was driving impaired and distracted. That's unreasonable and it's negligent. It's the failure to exercise ordinary care. Now, on July 11th, 2013, the defendant, he started his day off at Shell Beach. He had a flight to catch later that day, so he goes to brunch. And at brunch, you heard, I had margaritas for an hour, brunch took an entire hour, and then I got on the road. This was at 12:30. At 30 minutes into that drive, he enters Bayview State Park. And that's when the first opportunity the defendant had presented itself. Because the defendant, he saw the child standing on the side of the road. He acknowledged his presence, but he did nothing. He didn't change the way he was driving in any way. He just wanted to keep with the flow of traffic. Now, at this exact same moment in time, Mr. Flyberg, who you also heard from, was driving on the opposite lane. And he saw that child. The difference is that Mr. Flyberg, he did the reasonable thing. He paid attention to that child. And because he was paying attention, he was able to see the universal sign that that child was going to cross the street. He saw that child look both ways. Now, this is when the second opportunity presents itself to the defendant. Because the defendant, as I asked him on the stand, did you see that child take 2 steps towards the road? He said, yes, I did. He saw that child take those 2 steps towards the road. And at that point, he still did nothing. He kept his foot on the gas because the only thing he was worried about was about catching his flight later that day. He couldn't be bothered to be paying attention to a child on the side of the road. So he lets that opportunity pass him by. Now, back to Mr. Flyberg, because Mr. Flyberg's paying attention. He sees that child, and he slams on his brakes. And this is when the third opportunity presents itself to the defendant. Because the defendant heard the screeching of those tires and those brakes making contact with the road, and he did not react. He had seen the child the first time, had seen him take 2 steps towards the road, but now he's finally deciding to act. He looks to his left, and then he processes what's happening, and then he slams on his brakes. But by then, it's too late. He slams into the child, causing him to shatter his legs on impact, and sends him flying 30 feet across the street in the air, where he lands on the pavement, and he's instantly unconscious. That's just the eyewitness testimony that tells you the defendant was negligent. That's just the eyewitness's accounting of what happened. Because you also heard from experts today. You heard from 2. And each expert has a different opinion as to how and why Sam was hit as he crossed the road. The first expert you heard from was our expert, Dale Newcomb. And Dale Newcomb has 30 years of investigative experience. He did 20 in the major accident investigation unit with the state troopers. And then he went 8 years into his own business where he's reconstructed accidents. He's advanced his education. He's taken advanced physics courses, advanced computer simulation courses, just so he can come in here today and tell you exactly what happened. Because he built that accident from the ground up. And his conclusion was that if the defendant had been paying attention, wasn't impaired in any way, he would have been able to stop in time. And he created this graph. This is what he created for the purposes of today's trial. And this graph shows you Mr. Flyberg's data. Dale Newcomb's data that he came up with. And he used science to come to his conclusion. He took road conditions, he applied reaction times, and he applied visibility conditions of what the defendant and Mr. Flyberg saw. And at this point, the conclusion he came to was that two conclusions, actually. One, that the defendant was paying attention at about this point right here. He sees the child standing on the side of the road. This is where the child crosses the road and where he gets hit. Now, if the defendant at this point in time, this is the first opportunity, decides to slow down or pay attention, he's able to respond in time. But he misses that opportunity. The second opportunity happens shortly thereafter, when the child takes those 2 steps towards the road. And again, you see no action on the part of the defendant to respond in any way. It's because he's distracted and he's on the phone at this point in time. Mr. Flyberg told you he saw the defendant with his hands to his ear at this moment when they began to see each other. So we know he was on the phone. And we know that he lied to the officer that he was on the phone. And the third opportunity is when he hears the brakes. This is at this point, at 15, because that's when the first skid marks begin to show itself. At this point, the defendant is about 55 feet away from the moment of impact. Now, Mr. Newcomb told you that if the defendant reacted immediately when he heard the brakes, there would be no X, because the child crosses safely. But the defendant doesn't begin to brake until 40 feet, and that's what causes the tragedy. That's what causes the X, and it sends the child flying 30 feet. Those are the conclusions that the expert, Dale Newcomb, came to, based on his reconstruction of the accident. The other expert you heard from the defendant, was Trooper Fielder. Now, Trooper Fielder and Dale Newcomb do have some similarities in common. They both went to basic trooper school where they learned the basics of accident investigation. But Trooper Fielder hasn't taken advanced courses in computer simulation, hasn't taken advanced courses in physics. Trooper Fielder can't tell you how and why. Trooper Fielder can only tell you the measurements that our expert used. That's the extent of what Trooper Fielder can tell you. And Trooper Fielder came to the conclusion that there was nothing the defendant could have done based on visibility. Members of the jury, visibility is not in question here. The defendant told the trooper, I saw the child. I saw the child take 2 steps towards the road. It is a non-issue that has been presented to you in the guise of an expert. And members of the jury, I submit to you, you only heard from one credible expert that can tell you how and why the accident happened. And that was our expert. Now, the defense is going to come up here and they're going to try to blame the parents. They're going to try to turn it into a mere seconds, that this was just a snapshot in time that the defendant had no time to react. But we know that's not true. We know that the defendant saw the child, but chose to do nothing. That was the first opportunity. We know that the defendant saw the child take 2 steps towards the road. Again, nothing on the part of the defendant. He just kept his foot on the gas. And the third opportunity was when he slammed on the brakes. There is nothing the defense can tell you that is going to change those facts. There is nothing the defense can tell you that's going to change the fact that 30 minutes before he got on the road, he'd been drinking for about an hour while having brunch. These are facts that can't be changed. Now, as the plaintiffs in this case, it's our burden to prove to you, by preponderance of the evidence, that the defendant failed to exercise ordinary care and was negligent. Now, preponderance of the evidence is a different legal standard than what you may have heard before. It's not beyond a reasonable doubt. It's not a high standard. It's simply preponderance of the evidence, which means, is it more likely than not? Is it more likely than not that the defendant was negligent when he missed every one of those opportunities, chose to get behind the wheel while impaired, and then got distracted while driving? There is a scale. I want you to, one last thing on the preponderance of the evidence. I want you to picture a scale. And throughout the course of this trial, you've heard evidence that tilts it in one way. But if at any point it becomes 51%, that's the side that wins. I ask you, when you go back and review the evidence, I want you to carefully weigh everything you heard and all the evidence that was admitted. Because when you place a margarita, 2 margaritas, and 3 margaritas, you toss a cell phone on there, and then you add in those 3 opportunities that were missed, the scales of justice tip in our favor. And they say that the defendant was negligent and he's to be held liable as such. Now, your honors, defense is going to come up, and they're going to give their closing, and then I'm going to go give one last rebuttal, and then you're going to be asked to deliberate. And throughout the course of deliberation, the task is to complete a verdict form that you're going to be presented with. And I'd like to go over that verdict form with you at this point in time. The first question asked before you is, was the defendant, Lynn Snyder, negligent as alleged by the plaintiffs? The answer to this box is yes, because the defendant wasn't paying attention on the road. He let every opportunity pass him by to avoid hitting into that child. That's why the answer is yes. The second question asks, was the negligence of the defendant, Lynn Snyder, a proximate cause of injury or damage to Samuel Scruggs? The answer is yes. It was the defendant's Kia that he rented that day that slammed into Sam as he crossed the road and sent him flying 30 feet and landing unconscious. There's no dispute as to who caused the injuries of Sam that day, and that was the defendant. The third question, members of the jury, asks, were either of Sam's parents, Tammy or Pat Scruggs, or his sibling, Robin, a non-party for whose conduct the parents were responsible, negligent as alleged by the defendant? The answer to this question is no. The parents didn't do anything unreasonable. They entrusted their youngest child in the care of the oldest sibling who had taken babysitting courses at a hospital and had babysitted before and was fully aware of how to take care of a child. Families do that all the time. There's nothing unreasonable about that. Question 4 asks, was the negligence that you found in answering question 3 on the part of either of Sam's parents, Tammy or Pat Scruggs, or his sibling Robin, the proximate cause of the damages or injuries to Samuel Scruggs? The answer to that question is no. There was clearly an intervening act if you found negligence on the part of question 3. Because it was the defendant who drove into the child as he crossed the road. So the answer to that box is no. And question 5 asks to assume that 100% represents the total combined negligence that approximately caused Sam Scruggs damages. What percentage, if any, of this 100% is attributable to the defendant, Lynn Snyder, and the combined effects of Sam's parents and or his sibling? Under this box, where it says parents of Tammy and Pat Scruggs, including Robin Scruggs, you're going to put a 0% there. Under defendant, 100%. Because the defendant is 100% responsible for the injuries Sam suffered that day. It wasn't the parents that served him those margaritas and said, get on the road. It wasn't the parents that told him, hey, call the airliner, check if your 3:30 flight's on time, as he's driving through Bayview State Park and he sees a child standing on the side of the road. And it wasn't the parents that drove that car into Sam. Because Sam Scruggs interacted with the defendant that day on July 2013, his life has been forever altered. He's never going to be the same because he crossed paths with the defendant. The defendant had 3 opportunities, 3, to avoid hitting that child. He saw the universal sign when he took 2 steps towards the road, and he did nothing. And knowing that the child is on the side of the road and he hears the screeching of a truck, he still yet does nothing. It's because his reaction time is impaired because he had the margaritas before he got on the road. This was 30 minutes. He finished up his brunch, he paid his tab, and got on the road. And when he was on the road, he crashed into a child crossing the street. That's unreasonable, and it's negligent.
Missed opportunities. I want you to remember that. Missed opportunities. A moment in time. A moment, a flash, an instant. A blink of an eye. And that moment's passed. A blink of an eye, ladies and gentlemen of the jury, is what we have spent the majority of our time arguing about. But seconds will never be anything more than mere seconds. And fractions of seconds are exactly that. Fractions of seconds. The plaintiffs are trying to stretch each and every one of those fractions of seconds and attempting to say that Lynn had enough time to see, evaluate, and react. But in reality, it happened that fast. That fast. Plaintiffs have attempted to skew the perception of time. They've even gone so far as to hire a professional witness that, quote-unquote, gave Lynn the benefit of the doubt. A professional witness that was paid a grand total of $17,000. That professional witness was the plaintiff's witness. And a plaintiff's witness giving the benefit of the doubt to the person that didn't pay them. Ladies and gentlemen of the jury, fortunately for the law, fortunately for us here today, facts can never change. And we have to look at all the facts of this trial, not just the ones that are convenient for the plaintiff. And there are a couple of pesky facts that the plaintiff hopes you don't realize.
First, Trooper Fielder sat in this stand and explained to you that Lynn Snyder was not impaired. He confirmed that with not one, not two, not three, but 4 field sobriety tests, one of which being a voluntary field sobriety test that Lynn Snyder herself volunteered for. Why? Because she had nothing to hide. She was not impaired. This trooper, the lead accident investigator, the civil servant that was on scene, he didn't have to guesstimate. He didn't have to play out and build the actual scene because he was there. Second, Lynn was not speeding. Lynn was not swerving. Lynn in no way, shape, or form was driving recklessly. I will remind you that Jan Moriarty's testimony gave the eyewitness account of what she saw directly behind Lynn Snyder. Her perspective. And with that perspective, it's a very unique perspective. Why? Because she was in the same lane of traffic as the defendant. And from her view, she believed the actual accident to be screech bang. That fast. Screech. Third, the other car that had the possible misfortune of hitting this 6-year-old child was Mr. Flyberg. What the plaintiff hopes you won't recognize is that Mr. Flyberg was driving in the opposite lane of traffic. The side, as I showed in my cross, was standing right next to him. He had an unimpeded view. He said it himself. He locked on to the child. Consider that. Not just consider it. These are the facts as they've been shown. Miss Flyberg was in the opposite lane, with her view of the child not at the moment on the side of the road, but throughout the entire run, was obstructed by oncoming traffic. Ladies and gentlemen of the jury, consider that. Let's contrast that with the missed opportunities the parents, the plaintiffs had. Plaintiffs, although they had never been there, they had been all weekend here. Right next to the road, right next to the highway. They could not only see the highway, they could hear it. Even when they couldn't see it, they could hear the cars zooming past at up to 55 miles an hour and possibly above that, ladies and gentlemen of the jury. They knew there were no sidewalks. They knew there was no cross path. They knew there was absolutely no way that their 6-year-old child would be able to cross that highway, except for a dark, damp, underground tunnel, which even to an adult, let alone a 6-year-old child, would hesitate before entering. The idea for a 6-year-old to enter in this tunnel is far scarier than just crossing a road. And the parents should have known that because they were there all weekend. Despite knowing these things, despite having been there all weekend, the plaintiff still entrusted the life, the safety, the well-being of a 6-year-old boy, their son, to a minor, a teenager. A teenager, which we know, which is known that teenagers are still developing their own sense of responsibility. What did Robin do that day? Robin did what's expected of 15-year-olds. They're willing to be responsible as long as it meets their own motives. In his testimony, he specifically states that the reason why he was willing to take his brother to the other side was because he was interested in a romantic interest in Jessica. He wanted to spend time with Jessica. Going to the other side of the field to be with Jessica was fine. And unfortunately, on July 11th, 2013, Robin did what 15-year-olds do. He turned his back to his responsibilities. He put his brother behind him, next to a tree that's next to the road. Turned back around and decided that because Sam didn't want to play anymore, because it wasn't fair that 15-year-olds could play softball with 6-year-olds, that he didn't care about that because he wanted to play catcher with Jessica. And the painful truth for the parents, the plaintiffs, is that this moment, this missed opportunity, and all the opportunities leading up to that moment is what allowed for a 6-year-old boy to wander onto the side of a busy highway and attempt to run. Ladies and gentlemen of the jury, we're coming to the close of this trial. It's almost over. And at that point, the Honorable Judge Dobson will give you instructions. And it is your job, your responsibility, your duty as jury members to put aside your emotions, to put aside your feelings. Because once we enter this room, it's a court of law. Emotions and feelings are left outside. Your duty, your responsibility is to use logic and allow logic to come up with the answer collectively. And logically, there is no other decision that this jury can make other than defendant Lynn Snyder was not liable. Now in a moment, plaintiff is going to come back up here. They're going to try to muddy the waters that I was able to clear. And unfortunately, I will not have a chance to re-clear. So if the plaintiff is not able to answer why the parents shouldn't be responsible for this, and why Lynn was not responsible in her view, that should still be your verdict, not liable. Thank you.
Members of the jury, when you don't have the facts or the law on your side, you start to pound tables, because that's what gets the attention. But make no mistake about it, we're not talking about a blink. Oops, and then here's the accident. We're talking about 3 opportunities, because the defendant, as they just said, was driving slow. He was driving below the speed limit. So that means he should have been paying attention to the road. He saw that child on the side of the road. He saw that child take 2 steps towards the road and still does nothing. This is what he's doing. Oh yeah, I see the child. Oh, there he goes 2 steps. And then he slams into the child because he's not paying attention to the warning signs in front of him. And members of the jury, that's unreasonable and it's negligent. And that's what the defendant was. He wasn't paying attention and he missed every one of the opportunities he had to avoid causing a tragedy. And there's nothing that the defense said that changes those facts. When you go back and deliberate, I submit to you there's only one logical conclusion. And the logical conclusion says the person who hit that child on the side and sent him flying 30 feet is responsible and should have been paying attention and wasn't. And that's called negligence. And the defendant was negligent that day.